This Privy Council case on appeal from the Supreme Court of New South Wales is one of the most famous Australian negligence cases. An oil tanker called the Wagon Mound was loading oil in Sydney Harbour. Due to the negligence of the ship's engineer, some of the oil was escaping. This happened over quite some time, causing an oil slick which flowed to another wharf where two vessels were being repaired. The repairs involved the use of oxyacetylene torches. When the workers noticed the oil, they asked whether it was safe to continue, and they were told the oil was unlikely to ignite. However, there was some waste cotton floating on the oil. Sparks from the oxyacetylene ignited that cotton, and that in turn ignited the oil, which caused massive damage to the ships. The Privy Council considered whether the damage to the ships was too remote. After all, it was pretty unlikely that the oil would drift down to the other ships, and that there would be waste cotton floating on the oil, and that the sparks would happen to hit that waste cotton, and that this would be enough to ignite the oil. It was argued that the risk was so remote that the engineer was justified in doing nothing to prevent it. The House of Lords found otherwise. They didn't disagree that the risks of this damage were remote. However, they went back a couple of steps. They found that if the engineer had realised the oil was escaping, it would have been a very easy matter indeed for him to fix whatever was going wrong in the transfer of the oil and therefore prevent any risks, be they economic, environmental or safety risks flowing from the oil. Their lordships said, "The most that can be said to justify inaction is that the engineer would have known that the fire could only happen in very exceptional circumstances. But that does not mean that a reasonable man would dismiss such a risk from his mind and do nothing when it was so easy to prevent it. If it is clear that the reasonable man would have realised or foreseen and prevented the risk, then it must follow that the appellants are liable in damages. So even if a risk is remote, steps should be taken to prevent it if those steps are not too onerous compared to the risk."